Good day everyone. In this video, we're going to tackle about the Title 14 and 15, Section 135 to Section 152 of the Revised Corporation Code of the Philippines. Now, let's begin with Section 135.
In Section 135, it talks about the voluntary dissolution where the creditors are affected. So the creditors will only be affected when the dissolution of the corporate prejudices the rights of the creditors. So the procedures and the contents of the petition is first is that the petition for dissolution shall be filed with the SCC. And in this petition, it shall contain a sign of a board of directors if it is stock corporation or board of trustees if it is non-stock corporation. And it shall be verified by its president or secretary and that its dissolution was resolved upon by the affirmative vote of the stockholders representing at least two-thirds of the outstanding capital stock or by at least two-thirds of the members at a meeting of its stockholders or members called for that purpose. So meaning when it comes to the board of directors or trustees, it shall be voted by the majority and that its dissolution was resolved upon by the affirmative vote of the stockholders or members representing at least two-thirds of the outstanding capital stock or members for it to have an authorization for the dissolution of the corporation and the list of all creditors to be submitted to the SEC. The content of the petition shall also contain the reason for the dissolution, the form, manner, and time when the notices were given, and the date, place, and time of the meeting in which the vote was made. So if the petition is sufficient in form and substance, the SEC shall now order the corporation reciting the purpose of the petition, fix a date on or before which objection were due, may be filed by any person which the date shall not be less than 30 days nor more than 60 days after the entry of the order. So this gives the chance to the creditors affected to object to the dissolution of the corporation because it may prejudice the rights of the creditors. It is also necessary to publicly announce the copy of order at least once a week in 3 consecutive weeks in the newspaper published in the municipality or city of the principal office of the corporation or posted for 3 consecutive weeks in 3 public places. So upon 5 days notice given after the date on which the right to file objection is fixed and the order has expired, the SEC shall proceed to hear the petition filed and try any issue raised in the objection filed. And if there is no objection sufficient and the material and allegation of the petition are true, the SEC shall render judgment dissolving the corporation and directing such disposition of its asset as justice requests. And take note that the SEC may appoint a receiver to collect such asset and pay the debts of the corporation, and the dissolution shall take effect only upon the issuance by the Commission of a certificate of dissolution. So another kind of voluntary dissolution is by amending the articles of incorporation to shorten the corporate term, which is discussed in the Section 136. So Section 136 is the dissolution by shortening the term. This can only be done by amending the articles of incorporation to shorten the corporate term, and a copy of the amended article of incorporation shall now be submitted to the SEC. And the approval of the SEC is necessary before it could take effect. So upon the expiration of the shortening term, which is stated in the approved amended articles of incorporation, the corporation shall be deemed to be dissolved without any proceedings subject to the provision of this code on liquidation. And in case of expiration of the corporate term, dissolution shall automatically take effect on the day following the last day of the corporate term, stated in the Articles of Incorporation, without the need for the issuance by the Commission of a certificate of dissolution because there is already approval of the SEC to the dissolution of the corporation because the SEC already granted the corporation to the amendment in shortening the corporate term. In Section 137, it basically talks about the withdrawal of requests and petition for dissolution. This section is added in the Revised Corporation Code of the Philippines to have a clear understanding to the withdrawal of requests and petition for dissolution. The withdrawal of dissolution shall be made in writing duly verified by any incorporator, director, trustee, shareholder, or member, and signed by the same number who agrees to the withdrawal. It is necessary to request for dissolution as set forth in the foregoing section. This withdrawal shall be submitted no later than 15 days from receipt by the Commission of the request for the dissolution. And upon receipt of the withdrawal of request for dissolution, the SEC will now hold an action on the request for dissolution and shall, after investigation, the SEC will make a pronouncement that the request for dissolution is deemed withdrawn, and there will be a joint meeting of the board of directors or trustees and the stockholders or members for the purpose of ascertaining whether to proceed with dissolution or issue such other orders as it may deem appropriate, and the withdrawal of the petition for dissolution shall be in the form of a motion and in similar in substance to a withdrawal of request for dissolution, but shall be verified and filed prior to the publication of the order setting the deadline for filing the objection to the petition.
Title 14, Section 138, Involuntary Dissolution. A corporation may dissolve by the commission motu proprio or upon filing of a verified complaint by any interested party. Dissolution may order by the SEC either motu proprio, meaning its own initiative, or upon verified complaint. Grounds for dissolution of the corporation. Number 1. Non-use of corporate charter. Under Section 21, if a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, then its certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. In this case, the corporation continues to exist until the SEC orders its dissolution after notice and hearing. If the SEC declares the dissolution, the effect of such declaration will retroact or will go back to the time when the corporation was deemed dissolved. Number 2. Continues in operation of a corporation. If a corporation has commenced its business but subsequently becomes inoperative, the SEC may, after due notice and hearing, place under delinquent status. A delinquent operation shall have a period of 2 years to resume operations and comply with all requirements that the SEC may prescribe. And upon compliance, the SEC will now issue an order lifting delinquent status. But failure to comply with the requirements and to resume operation within the period will cause the revocation of the corporation's certificate of incorporation, which results to dissolution. Number 3. Upon the receipt of a lawful court order dissolving the corporation, meaning there is a case before the court and the court has found that the corporation should be dissolved. Number 4. Upon finding by the final judgment that the corporation procured its incorporation through fraud, their incorporation was fraudulent. Final judgment is needed. Upon finding by final judgment that the corporation, letter A, was created for the purpose committing, concealing, or aiding the commission of securities violations, smuggling, tax evasion, money laundering or graft, and corrupt practices. Letter B, committed or aided in the commission of securities violations, smuggling, tax evasion, money laundering, graft, and corrupt practices, and its stockholders knew of the same. And letter C, repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. Take note that the SEC and the courts may order the dissolution of the corporation on the grounds. Let's talk about the third paragraph. If the corporation is dissolved by final judgment, the assets of the corporation after payment of its liabilities shall upon the petition of the SEC with the appropriate court. The assets shall be forfeited in favor of the government with prejudice to the rights of innocent stockholders and employees for services rendered, and to the application of other penalties or sanctions under the law. Section 139 of Title 14 Dissolution is corporation liquidation. General rule that every corporation whose charter expires pursuant to its articles of incorporation is annulled by forfeiture or whose corporate existence is terminated in any other manner. Section 139 grants the corporation a period of 3 years after dissolution within which to wind up its affairs. Any claims by or against the corporation which are not presented and settled within the period becomes unenforceable. Why? Because there is no longer any corporate entity against which they may be enforced. However, if there is nothing in the law that prevents an action for the recovery of debts of corporation against the liquidator after the lapse of the 3-year winding up period. But, except for the banks that are covered by the applicable provisions of Republic Act No. 7653 or the new Central Bank Act, otherwise known as the Philippine Deposit Insurance Corporation Charter. Until the corporation is liquidated, no part of subscribed capital may be returned or released to the stockholders without violating the trust fund doctrine, except in the case of redeemable shares. Now, let's move on to another title, which is Title 15, Foreign Corporation. A corporation organized the laws of the Philippines is called a domestic corporation with respect to the Philippines, and it's a foreign corporation with reference to the other states, although it is formed here and in other country or state, we will be considered it as a foreign corporation. So the first section under Title 15 Foreign Corporation is Section 140, which is Definition and Rights of Foreign Corporations. For purpose of this code, a foreign corporation is one formed, organized, or existing under laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining a license for the purpose in accordance with this code and a certificate of authority from the appropriate government agency. Under Section 140, a foreign corporation must first obtain a license and a certificate from the appropriate government agency before it can transact business in the Philippines. When a foreign does business in the Philippines without proper license, it cannot maintain any action or proceeding before Philippine courts, as provided under Section 150 of the Revised Corporation Code.
Now, let's proceed to the Section 141. For the application to the existing foreign corporation, Section 141 states that foreign corporations which, on the date of the effectivity of this code, is authorized to do business transactions as long as it has a license which give them authority under the terms and condition of the license subject to the provision of the code and special law. Let's go with the Section 142, Application for a License. When a foreign corporation is applying for a license, it must submit to the Commission a copy of its articles of incorporations and bylaws certified under translation to an official language of the Philippines. Also, it must include the following: the date and the term of incorporation, the address of the principal office of the corporation, the name and address of its resident agent who is authorized, the place of the Philippines, the corporation, and let's go with the specific purpose that the corporation wants to pursue, but the specifically stated in the certificate of authority issued by the appropriate government agency, the names and address of the present directors and officers, a statement of its authorized capital, stocks, and shares which they have authority to issue, a statement of its authorized capital, stocks, and shares which they issued, statement of amounts actually paid, and additional information that may be deemed necessary for the validation of the Commission, take note that according to the doctrine of isolated transactions, foreign corporations, even licensed ones, can sue or be sued on a transaction apart from their common business in the sense that there is no intention to engage in a progressive pursuit of their purpose of transaction. Now, let's proceed to the section 143, the issuance of a license. Section 143 states that transacting business means the carrying on of the operation of the corporations or some portion of them in the usual and regular course of the prosecution of the corporate enterprise for profit. The Corporation Code outlines the procedural requirements for the application and issuance of a license before a foreign corporation may transact business in the Philippines, except in cases of a foreign banking, financial, and insurance corporations and others subject to special laws, rules, and regulation if the applicant of a foreign corporation has complied with all the requirements of the issuance of a license. The SEC or the Securities Exchange Commission shall issue such license, and thereafter the foreign corporation may transact business in the Philippines. Section 144. Who may be a resident agent? A resident agent may be either an individual residing in the Philippines or a domestic corporation lawfully transacting business in the Philippines, provided that an individual resident agent must be a good moral character and of sound financial standing, provided further that in case of a domestic corporation who will act as a resident agent, it must likewise be a sound financial standing and must show proof that it is in good standing as certified by the Commission. Resident agents, number 1, an individual residing in the Philippines, and he must be a good moral character and a sound of financial standing. Number 2, a domestic corporation lawfully transacting business in the Philippines and must likewise be of sound financial standing and must show proof that it is good standing as certified by the Securities and Exchange Commission. Purpose of appointing a resident agent. Number 1 is notice affecting the corporation pending the establishment of its local office, and number 2, mga summons and other legal process in all proceeding for or against the corporation. Take note that the appointment of a resident agent of a foreign corporation is revocable at any time at the instance of the corporation. Section 145, Resident Agent, Service of Process. As a condition to the issuance of the license for a foreign corporation to transact business in the Philippines, such corporation shall file with the Commission a written power of attorney designating a person who must be a resident of the Philippines, on whom summons and other legal process may be served in all action or other legal proceedings against such corporations, and consenting that service upon such resident agent shall be admitted and held as valid as if served upon the duly authorized officers of the foreign corporations and its home office. Such foreign corporation shall likewise execute and file with the Commission an agreement or stipulations executed by the proper authorities of said corporations in form and substance as follows. So, resident agents act as a representative of one foreign corporation. So, the primary of a resident agents is to receive in behalf of the foreign corporations notices, summons, and other legal processes in connection with actions against such corporations. Also, resident agents has no control over the assets of the corporation. Take note that the service of any such papers on such resident agents has the same force and effects as if made upon to do the authorized officers of a foreign corporation at its own office. Whenever such service of summons or other process is made upon the Commission shall within 10 days thereafter transmit by a mail or a copy of such summons or other legal process to the corporations as its home or principal office. The sending of such copy by the Commission shall be a necessary part of and shall complete such service. All expenses incurred by the Commission for such service shall be paid in advance by the party at whose instance the service is made. It shall be the duty of the resident agent to immediately notify the Commission in writing of any change in the resident agent's address. Purpose of summons. The purpose of summons is not only to acquire jurisdiction over the person of the defendant, but to give notice to the defendant that an action has been commenced against it, and to afford it an opportunity to be heard on the claim made against it. Take note, the requirement of the rule on summons must be strictly followed, otherwise the court will not acquire jurisdiction over the defendant. Section 146. Law applicable. A foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class, except those which provide for the creation, formation, organization, or dissolution of corporations, or those which fix the relation, liabilities, responsibilities, or duties of stockholders, members, or officers of corporations to each other or to the corporation. So, when it comes to the operational or transactions of foreign corporations here in the Philippines, Philippine laws apply. But when it comes to the organizations or internal affairs of the corporations, the laws of state of creation is
Let's proceed to section 147, where I will be discussing the procedure and requirements for foreign corporations doing business here in the Philippines when amending their articles of incorporation or bylaws. Specifically, we will talk which governs these amendments and how foreign corporation must comply with the filing process with the SEC. According to Section 147, where a foreign corporation, which is authorized to transact business in the Philippines, makes amendments to its articles of incorporation or bylaws, it must comply with certain filing obligations. These provisions are designed to ensure that all changes are properly documented and made available to the relevant authorities in the Philippines. In filing requirements, when a foreign corporation amends its articles of incorporation or bylaws, it is required to submit a duly authenticated copy of the amended documents to the SEC. This filing must be done within 60 days from the effective date of the amendment. In addition to SEC, the amended articles of incorporation or bylaws must, in appropriate cases, also be filed with the relevant government agency in the foreign corporation's home country or state of incorporation. This ensures that the amendment is also recognized and validated in the jurisdiction where the corporation was originally established. And in filing the requirements, it includes the following. The foreign corporation must submit a clear and authenticated copy of the amended document indicating the changes made. This can be done by capitalizing the amended text or underscoring the parts that were modified. This helps to easily identify what changes were made to the original document. Additionally, the amended articles or bylaws must be duly certified by the authorized officials of the foreign corporation's home jurisdiction. It is also important to note that the filing of the amended articles of incorporation or bylaws with the SEC does not itself alter or enlarge the purpose for which the foreign corporation is authorized to conduct business in the Philippines. In other words, any changes made in the amendments should be related to the internal governance or structure of the corporation. However, the amendment should not result in a change to the foreign corporation's originally approved business purpose in the Philippines, unless this is explicitly approved by the SEC. Let's continue to section 148, where we will cover its key requirements. Under section 148 of the Revised Corporation Code of the Philippines, which deals with the need for foreign corporation to obtain an amended license when certain changes happens in their operations in the Philippines. Here we will focus on two key scenarios. changing the corporate name, and pursuing new or additional business purpose in the country. Again, under Section 148 of Foreign Corporation that is authorized to transact business in the Philippines must apply for an amended license in the following cases. First is the change of corporate name. If the foreign corporation decides to change its registered name, it is required to obtain an amended license from the SEC. Second, the expansion of business purposes. If the foreign corporation wishes to pursue new or additional business purposes in the Philippines beyond those originally approved, it must also apply for an amended license. To obtain the amended license, the foreign corporation must submit an application to the SEC. In certain cases, this application must also be endorsed by the relevant government agency in the corporation's home country or state, especially if the change involves a matter regulated outside the Philippines. In short, a foreign corporation must secure an amended license with the SEC when they change their corporate name or expand their business purposes in the Philippines. This ensures that all operational changes are properly documented and approved in accordance with Philippine law. For the next section, we will discuss the provisions under Section 149 regarding mergers and consolidations involving foreign corporation authorized to do business in the Philippines. Here in Section 149, it outlines the requirements for foreign corporation that wish to merge or consolidate with domestic corporation in the Philippines. Under this section, the following points are crucial. One or more foreign corporations that are authorized to transact business in the Philippines may merge or consolidate with domestic corporation, provided that such actions are permitted by both Philippine laws and the laws of the foreign corporation's country of incorporation. Also, the merger or consolidation must comply with the requirements set out in the Philippine Corporation Code. If a foreign corporation is involved in a merger or consolidation, it must submit the following documents to the SEC within 60 days of the effective date of the merger or consolidation. A copy of the articles of merger or consolidation. The document must be duly authenticated by the proper officials in the home country or state of incorporation. Additionally, if the absorbed foreign corporation is the one doing business in the Philippines, it must also file a petition for the withdrawal of its license to do business in the country. To summarize Section 149, foreign corporation in Philippines must follow the legal processes for mergers or consolidations with domestic entities. They must file the appropriate documentation with the SEC, and in cases where the foreign corporation is absorbed, they must request or file a petition for withdrawal of their business license in accordance with this title.
Continue the discussion on Title 15, Foreign Corporations. I will now be proceeding to Sections 150 to 152 of the Revised Corporation Code. To start, Section 150 prescribes for the doing of a business of a foreign corporation in the Philippines without a license, which states that no foreign corporation transacting business in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines, but such corporation may be sued or proceeded against before Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. Thus, the general rule under this section is that no foreign corporation transacting business in the Philippines shall be permitted to sue on any Philippine courts. The exception is when the doctrine of estoppel applies. It shall be known that a foreign corporation that is not transacting business in the Philippines is not required to have a license. Hence, they are not ipso facto incapacitated to bring an action against the Philippine courts. Proceeding with Section 151, which provides for the grounds for when the license of a foreign corporation may be suspended or revoked, without prejudice to other grounds provided under special laws. The license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Commission upon any of the following grounds: failure to file its annual report or pay any fees as required by this code, failure to appoint and maintain a resident agent in the Philippines as required by this title, failure after change of its resident agent or address to submit to the Commission a statement of such change as required by this title, failure to submit to the Commission an authenticated copy of any amendment to its article of incorporation or bylaws or any articles of merger or consolidation within the time prescribed by this title, a misrepresentation of any material matter in any application, report, affidavit, or other document submitted by such corporation pursuant to this title, failure to pay any and all taxes, imposed, assessments, or penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions, transacting business in the Philippines outside of the purpose or purposes for which such corporation is authorized under its license, transacting business in the Philippines as agent of or acting on behalf of any foreign corporation or entity not duly licensed to do business in the Philippines or any other ground as would render it unfit to transact business in the Philippines. Lastly is Section 152, which provides for the issuance of Certificate of Revocation. Upon the revocation of the license to transact business in the Philippines, the Commission shall issue a corresponding Certificate of Revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The Commission shall also mail the notice and copy of the Certificate of Revocation to the corporation at its registered office in the Philippines. Thus, upon the revocation of the license of a foreign corporation, the Commission shall issue a copy to the appropriate government agency and to the corporation itself.
That's all for the discussion of Title 14 and 15, Section 135 to 152 of the Revised Corporation Code of the Philippines. Hope you learned something and thank you for listening.